So under the constitution in India, broadly, I think you may find certain parallels of what exists in Kenya. You have the legislative branch, which makes the laws. You have the executive branch, which enforces it. And you have the judicial branch, which hears quite often challenges which are premised on judicial review of the laws as well as the executive actions. Now, quite often, when we look at technology, we do look at it with a sense of opportunity and what it offers to us in terms of tangible benefits, especially for the global south, which looks towards addressing a large amount of the social problems which exist in our societies. And here, for instance, teleconnectivity and the smartphone offers people the ability of mobility, not only through their devices, but social mobility. A poor person can, through remote learning, remote health, avail certain facilities which were not traditionally available to them. And here, the smartphone and internet is no longer viewed merely as a convenience or a business function, but intrinsically linked to all of our lives. Now, in this recognition, if you just look at the teleconnectivity statistics in a city like Delhi, there are 3 broadband connections for every person. There are less people, there are more broadband connections. But that does not mean that every person has a broadband connection. Apar Gupta will have 4, but a person who provides a blue collar service, let's say in any of our houses in terms of housework, may be a family which is sharing just one smartphone device. So the very base of digitization, whenever we look at it, has to be in terms of access and overcoming the digital divide, which links to a constitutional value of equality before law, which I think is a shared value between many post colonial constitutions. But it is also incumbent quite often, which we have seen in post colonial countries, is that the legislative and the executive branches are still growing into that democratic framework. It's not as if you adopt a constitution and from the very next day the lawmakers start imbibing a democratic culture. These cultures are built over time, which is a recognition of why the judicial branch conducts judicial review, is the law which is passed as per the powers of parliament. And I think Kenya here has struck down a compulsory biometric system which was called coercive as unconstitutional. Unfortunately, I was part of the Supreme Court challenge in India, and I think the dissenting judgment did provide value to the Kenyan Supreme Court subsequently. However, I would personally refrain from expressing opinion. I was a lawyer in that case, but I guess you can see the expression on my face. But the benefit of these kind of cases quite often is also a form of incrementalism, where we learn from the past, in which the win and losses may be immaterial, but we learn from the past. And here, I would just like to talk a little bit about internet shutdowns and the work my organization does. So I practice law, and there was a vacuum we noticed in India where there is a lot of capacity building. There are a lot of organizations in India which conduct research, but pure play advocacy, or what is called strategic litigation, parliamentary engagement, policy processes in which you participate in a public consultation, file RTIs, or also align with citizen movements when they ask for certain forms of economic or social justice is absent. And quite often these movements do face a form of censorship. I'd just like to illustrate how we have done this work at IFF on internet shutdowns. Internet shutdowns were being done in India since 2013, especially on issues of internal security. And to a large extent, the people did not really mind this was happening. And these were being done under curfew powers under the Code of Civil Procedure, as well as the Indian Telegraph Act, which is, I think, so similar to the Telegraph Act, which exists in a lot of post-colonial countries. It was a British law. It's been changed now, but the provision is the same, which also allows an internet shutdown. Now, the problem which was occurring was that people were not informed why the internet was shut down. A legal order under that was not published with the reason stated why the internet is being shut down, from when till when. And if we look at international human rights instruments, an internet shutdown is somewhat of a hammer rather than a chisel. It is disproportionate. So the doctrine of proportionality, which says that, okay, if you want to prevent an issue of internal security, you ban these 10 websites for this period of time, does not apply to internet shutdown, which is a complete blockage of the internet itself. So when the internet was shut down in Jammu and Kashmir, certain petitioners approached the Supreme Court. We assisted some journalistic bodies, and the Supreme Court gave a decision that there needs to be a published legal order which needs to have reasons, and an internet shutdown cannot be indefinite. Even subsequent to that, this form of transparency has not led to accountability immediately in the sense of people then getting these orders, rushing to court and challenging them. But what have the other branches of government done? The Parliamentary Committee on IT has published a report on internet shutdowns and has said, what are the economic justifications? Does it actually prevent violence? Is there any economic study of the costs which come through it? Because you can't even transact through what you hear about quite often, the UPI. And India, as per civil society sources, has the number one, the bad rank of being number one on internet shutdowns, right? And India shouldn't be on that list, according to me. We are a world leader on digital technologies. And I think so this has led to some form of recognition and reform over a longer period of time. I think internet shutdowns are done not only for internal security, they have also been implemented for preventing cheating in exams. They have been implemented to prevent citizen protests on smaller issues. And I think that this is something which also impacts people who are in blue collar professions, who are gig workers, who are part of India's larger Digital India program and rely on social security benefits. IFF has done one report with ground surveys in Rajasthan, which is an Indian state, in which we asked people how do internet shutdowns impact daily wage laborers, people who work in the gig economy, for instance, an Uber, a DoorDash, Zomato, a Swiggy, those food delivery apps. I would like to end by stating that there's a great degree of what Commonwealth jurisdictions learn from each other. As post-colonial countries who are growing into a culture which is democratic, hopefully, it's not uniform. We take 2 steps forward, we dance a little on the side, we come a little back, we do a little jig all the time, right? But there's something to learn between us. And the great benefit is our Supreme Courts also signal to each other and they read each other, right? So if you are ever looking for any opportunity in terms of Indian precedent on the intersection of law, democracy, rights, and technology, please do reach out to me or my colleagues at IFF. We have conducted close to 54 strategic litigations on a wide array and canvas on digital technology and how it touches upon fundamental rights. Thank you so much.